welcome everyone to our call-in today. My name is Darcy Kemnitz. I'm the Executive Director of the National LGBT Bar Association. I'm happy to be sitting here with our Chief Program Officer, Judi O'Kelly. We are delighted, we're delighted to bring you information, although we're certainly not delighted to be discussing this matter. We are going to share insights from our brilliant speakers with unique thoughts and positions on this troublesome case. And we want to hear from our members as well about the Supreme Court's ruling in Masterpiece Cakeshop. So by way of introduction, I'd like to introduce you to Attorney Rose Saxe. She is Senior Staff Attorney with the ACLU's LGBT and HIV Project, and Professor Tobias Barrington Wolff. He teaches civil procedure and con law at the University of Pennsylvania School of Law as our speakers today. So official welcomes and salutations to Ms. Saxe and Professor Wolff. I am going to be handing this off to Judi to facilitate this call for the bar. Go ahead, Judi.
Thanks, Darcy. Welcome to all of you, our members, and welcome to Ms. Saxe and Professor Wolff. We really appreciate your joining us for the call today. So I thought we could just kick off with an overview. Can the two of you talk to us a bit about the Cakeshop ruling itself and why it's technically narrow in terms of the actual legal decision that the court handed down?
Sure. I'll take a start, and Tobias, you can jump in as well. And thanks so much, Darcy and Judi, for bringing us onto this call together with everyone. As folks know, the ACLU was counsel of record for the couple in this case, and like many others, we are disappointed with the decision. But at the same time, we are there is a lot to feel positive about, and I think that that's a really important takeaway here. This case, of course, was part of a much larger campaign on both the anti-equality and as well and the pro-equality side. The bakery here is seeking a very broad ruling on both free speech and religion grounds to give them a right to refuse service. And the decision really didn't address the core issues. Instead, they rested on what the Supreme Court justices viewed were improper action by the Civil Rights Commission in the state of Colorado. And part of that were some comments that some of the commissioners had made during the adjudicatory process, expressing concerns about the use of religion to discriminate, as well as a question about whether there had been even enforcement. And the enforcement question had to do with a man named William Jack who had gone to several other bakeries seeking anti-gay cakes and had been refused such cakes and had then himself filed civil rights complaints claiming that he was refused service because he was a Christian. And the commission had rejected those claims on the grounds that they were about, the businesses were entitled to have policies about not making offensive cakes. And the court said, well, that's really not, we're not clear that you're treating everybody the same. If you really just have an offensiveness exemption, then, who gets to decide? And as the concurring opinion by Justices Breyer and Kagan made clear, of course there can be a very different explanation that is legitimate for that difference in outcome in the different scenarios, which is that the clients in the Masterpiece Cakeshop case were refused service because they were a same-sex couple. They tried to buy a wedding cake and were refused, whereas in the William Jack context, he was not refused because he was a Christian. The thing that he was refused only because of the specific message that he sought, and it had nothing to do with his identity. They would not have sold that same cake to anybody regardless of their faith, which again is very different than the bakery in the Masterpiece case, which was asked to sell the same product to same-sex couples and had refused. As disappointing as the decision is for our clients, I think it's really important that the court recognize that in general, states can have LGBT protective non-discrimination laws, as well as recognize that any future consideration of this issue in a later case would need to take into account the dignity of gay people and to make sure that they are not exposed, that as we go about our day-to-day life, that we do not see, anti-LGBT signs in a wide range of businesses. And so, again, I think that as disappointing as it is that the court did not fully embrace or fully reject the arguments made by the bakery, the court did not go anywhere near as far as they were hoping. And as I think about going forward, I think one of the real questions is going to be, what does anti-religious bias mean? And we're already seeing efforts by the Alliance Defending Freedom to spin sort of mere enforcement of the laws as improper evidence of hostility.
So let me build on what Rose just said and make a couple of observations about how this case fits into the trajectory of legal and constitutional doctrine in this field that we've been working on for a long time. So, for starters, Rose, of course, is absolutely correct that the court didn't rule on these broad arguments. It did sort of gesture in their direction at a couple of points. And one of the things that the court said was, we can assume that a religious officiant, like a minister, could not be required to perform a wedding that he or she doesn't want to perform. And I think everybody has long since acknowledged that that's true, and that's an application of the so-called ministerial doctrine or ministerial exception to the free exercise clause. But the court also said, we can also assume that as a general matter, everybody has to abide by neutral laws that don't treat people differently based upon their religious identity. And it cited the Employment Division versus Smith case, which a lot of people on the call are probably familiar with. And that was just kind of a toss-off statement, but it really does seem to signal that the court is very skeptical of the much broader free exercise clause arguments that Alliance Defending Freedom was trying to make. That the court, in essence, suggested the role of ministers as religious officiants, that's carved out. But otherwise, the general principle is that people have to abide by neutral and generally applicable laws. So that was an important statement. The court didn't really say anything at all about the free speech arguments, other than to say that while it might be understandable on a sort of emotional level why people who own businesses that involve some kind of artistic or creative skill might want to be able to pick and choose their customers, it would raise a whole bunch of very difficult questions about how you would actually administer that doctrine, where you would draw the line. If you started going down that path of saying that certain businesses have a First Amendment right not to abide by anti-discrimination laws. Now, they didn't decide the issue. They made that sort of gesture in a very gentle way. But the fact is that that argument, that if you start going down that path and saying, well, some businesses get First Amendment exemptions from laws that they don't like, then it's difficult to know how you would ever have an administrable principle where you would draw the line. That's an argument that we have been making in these cases the whole time. And the court seemed to acknowledge that it would be a very difficult doctrine to administer if they went down that path. So I think that was a somewhat promising gesture on that larger issue. And the last thing I'll say, building on Rose's description of the record that the court relied on in concluding that there was bias in the administration of this particular law in front of this particular commission, I have a somewhat different reaction than a lot of my friends and colleagues in the advocacy community to this part of the court's ruling, which is that for decades we have been trying to get courts to take seriously the idea that minority litigants and disempowered litigants can sometimes face a very hostile reception when it comes to the enforcement of neutral laws, whether it's from law enforcement officials or whether it's from judges or tribunals. And that courts have to think a little bit more expansively about what bias looks like in that setting. And the fact that the court found bias on a relatively thin record in this case is very unfortunate for the outcome of this case, and it suggests that we're going to have to be facing a lot of efforts by people like Alliance Defending Freedom to bring bias claims in a whole bunch of other settings. But I want to take the court at its word that it thinks that there are some general principles here about how you identify bias in the administration of neutral laws. And I think that people who have been experiencing bias that we have often been fighting for might look to this opinion and say, look, if we're going to take this seriously, then you've just given us a much more expansive and nuanced way of approaching questions of bias in the administration of neutral laws. And so it worked against the couple that a lot of us were more sympathetic to in this case. But if the court really means what it said, then I think it opens an opportunity for some discussions about bias in the administration of our laws that we've actually been trying to push the court to take seriously for a long time.
Thank you, Tobias. That's very instructive, and I think we will talk more later in this call. I have some questions that delve a little bit more into that question of how commissioners may need to change what their actions and what their statements are in this process. I'm hoping we can flesh out a little bit more about the opinion itself, and maybe I'll kick it back to Rose for this. Can you talk a bit? You already mentioned, Rose, the Breyer-Kagan concurrence. Can you talk a little bit about the other concurrence and somewhat about Justice Ginsburg's dissent as well, and what impact each of those have had in shaping what we find about this case and what the aftermath may be?
Yeah, I mean, I think the dissent pointed out, from my perspective, I think rightly, but I definitely hear what Tobias is saying around the importance of looking critically at a record to make sure that everybody is indeed given a fair shake. I think the dissent, the main area of disagreement there was, of course, whether there was enough bias to send it back, and the fact that they would have resolved the issue on the merits and upheld the non-discrimination laws. I think the Gorsuch opinion really sends that's where sort of this question of what does the differential treatment of other kinds of bakers or kinds of products or kinds of people, how does that matter? And how do we think about that? And I think that is really going to be a core and critically important question for the viability of our laws against discrimination. Because on some level, while this is a free speech kind of question, it's also an equality kind of question, and whether we can have laws against discrimination that say that you can't be turned away because of who you are, but that does not mean that all businesses, whether in order to keep those laws, all businesses have to serve everybody, all kinds of products, because being denied service because the service you're seeking or where you're seeking to do something anti-LGBT or, a refusal to print, for example, a white supremacist T-shirt, if that is viewed as akin to turning away a person of color because of who they are, I think we've gone down a very, very concerning path. And I think the Kagan concurrence, Kagan and Breyer's concurrence really highlights sort of a very different view of what that, how those laws should work, and what equal treatment means in that context.
Yeah, I definitely agree with that. And I would characterize Justice Gorsuch's concurrence as an attempt to provide a roadmap to advocacy organizations like Alliance Defending Freedom for how they can push on the court's holding to subvert the enforceability of these anti-discrimination laws going forward. It's an issue that we've seen in a whole lot of these cases. How do you frame the comparison, right? When you're talking about whether a business or a workplace is treating people differently based on a protected characteristic, how do you frame the comparison? And one of the things that Alliance Defending Freedom and some of these other lawyers have been trying to do is to say, well, when you turn away a gay couple who are asking for a wedding cake or asking for photography services or whatever, that's not discrimination because they're gay. It's a different kind of service that they're asking for, or it's turning them away because of the sincere religious objections of the business owner, not because they have a discriminatory policy. And we've had to spend a lot of time in court in these cases or in our papers explaining to judges why those arguments are incorrect, and really sort of going to the very basic structure of how anti-discrimination laws work. And I see a lot of what Justice Gorsuch is, I think, attempting to do in his opinion is to frame anti-discrimination laws in a way that will give a stronger ability on the part of religious adherents who want to be able to turn away disfavored customers, to say that they're the ones who are being discriminated against when anti-discrimination laws are enforced against them. And it's an argument that's been sort of a big part of the playbook of organizations like Alliance Defending Freedom for a long time. And, part of what these cases have required us to do is to get better at explaining to courts and indeed to the general public how anti-discrimination laws work, and that, there's a difference between turning somebody away because he's white, which you're not allowed to do, and turning somebody away because he's a member of the KKK, which, thank God, is not the same thing as being white and is, in fact, not a protected characteristic under any anti-discrimination law that I'm aware of. And these are tough conversations, but they're necessary conversations, and I see Justice Gorsuch trying to make those conversations more difficult, or at least push them in the direction of the Alliance Defending Freedom position.
Thank you, Tobias. So I think what I would like to do is kind of move toward exploring more. You both teed up a number of issues that get to the ramifications of this case, and I'm sort of dividing the questions I want to ask you next into two different sort of spheres. First, there's the follow-up of what this will mean strictly on the process side of, what do adjudicators in situations like this need to do to improve the process going forward to meet the court's mandate. And then I think that we'll talk about the broader implications for what this may have unleashed in the way of test cases that will be coming out from the religious right and supported by groups like ADF that have been identified as anti-LGBT hate groups by groups like Southern Poverty Law Center. So I want to take them in that order. I do want to say first for our membership, we would be happy to address a few questions. I think we're not going to have a lot of time at the end, but if you have a question you'd really like to ask, please email that to Darcy, D-A-R-C-Y, @lgbtbar.org, and Darcy will give them to me and we'll pass them along at the end of the call as we have time. So coming to this procedural question, would you both be able to talk to us a bit about what future commissioners in human rights commissions across the country, to the extent that those commissions are adjudicatory bodies in cases like this, in the way that Colorado's commission was, what will they be able to say as they're doing adjudication in order to skirt the line that Justice Kennedy's opinion has drawn and stay neutral as they process these cases?
Well,
sorry,
go ahead, Tobias. Yeah, no, Tobias, you want to start with this one?
I'll just make a first initial observation, which is that, a lot of what the court rests on is what you might describe as editorializing by judges and quasi-judicial officers, commission members. And I guess one answer to the question is that they can simply stop editorializing. And there's actually a serious question about whether that's an appropriate or professional way for a tribunal or a judge to preside over a dispute in any circumstance. And, any lawyer who appears before courts or commissions knows that this kind of editorializing happens all the time. Judges have lots of opinions, and they often express those opinions from the bench or from the podium or whatever the case may be. And I suppose it's possible that commissions and tribunals and maybe even courts will take this decision as a signal that maybe they should kind of, tamp down on the editorializing comments. I don't know if that's a good or a bad thing, but I think it would be a relatively easy thing for tribunals to do if they think it's going to make a real difference in how their decisions are reviewed on appeal. The bigger issue which Rose touched on a minute ago, is the suggestion that the Commission was not engaged in an even-handed review of the claims of the gay couple in this case as compared to the claims of the tester, the anti-gay guy who went asking for all these anti-gay cakes to see if he could get turned away. And there, I think Justice Kagan's concurring opinion is a very important document because she, I think very convincingly, makes it clear that there was a perfectly legitimate basis for the Commission to treat these cases differently. And that's where I worry that commissions and perhaps lower courts are going to be a little bit intimidated into accepting claims from claimants that they shouldn't be accepting in order to avoid this suggestion that they're not being even-handed in the way that they administer these laws. That's, I think, what we're going to have to be on the lookout for.
Yeah, and this is Rose. I very much share that concern. And I think, though, that it is important that they look at which claims they're getting, that they are putting, that they not sort of go overboard and start considering bias or, sort of these kinds of test claims that really aren't legitimate claims, but that they do take seriously claims of religious discrimination. We know there is widespread discrimination against people of faith, particularly minority faiths, and that I think that those claims should be treated with just as much seriousness and respect. And I think that where you have that happening, and with also ensuring that there isn't this kind of editorializing. I think the line between editorializing versus expressing concern about discrimination, which as a commission they're entitled to do, is a complex one. But I think really just making sure that they're taking a hard look at the kinds of cases that they are bringing, and making sure that when they're adjudicating, that there isn't anything that can be used against them, and recognizing that we are an incredibly diverse and pluralist society, and that is our strength, and that no tribunal is going to be identical to all of the litigants that come before them, or the complainants on either side, and that we can move forward treating people with respect, but that respect does not mean what Alliance Defending Freedom is trying to argue is, their take is that respect means they have to get their way. And we have to be able to live in a world where you can disagree with somebody and you can even criticize their behavior or call their behavior unlawful without that being deemed impermissible hostility.
Yeah, I would recommend to anyone on the call who's interested, if you haven't done so, to read the majority opinion, read the whole case, but certainly read the majority opinion in Masterpiece Cakeshop. It is remarkable what statements by these two commissioners the court identifies as problematic. The first pair of statements are statements where a commissioner is essentially saying, look, the way the law operates is that if you have a set of beliefs and you don't want to serve certain customers, you may need to compromise on those beliefs, or you may need to recognize that you can't act on those beliefs in the context of the commercial marketplace. And by themselves, it would be almost absurd to suggest that these remarks indicate bias. And it's really a much more sort of pointed editorial remark that a second commissioner makes at a second hearing 2 months later that the court, I think, really sort of seizes upon in order to say that these people didn't get sufficiently respectful and neutral treatment. But whatever one thinks about that, there has to be a role for courts and commissions to engage in a certain law-declaring function, to engage in a certain, articulation of norms in the process of hearing these cases. And, I said a little while ago that there are elements of this inquiry that we might welcome because we've been asking courts to engage with questions of bias in a more robust fashion. But Rose is absolutely right to sound a note of concern as well, because what the court seized on in order to do that in this case it's really, if you took it out of the context of this particular case, it would be difficult to imagine an argument that much of what they look to would have anything to do with bias. And that's obviously what Alliance Defending Freedom is trying to capitalize on, the idea that they can't even be criticized or they can't even be told that their position is not going to prevail without some suggestion that there's bias in the way that they're being received. And that would simply be both wrong and dangerous.
And one other piece of the puzzle here, if I can just jump back in, I think that's important, is that there is a cert petition still pending in another case, Arlene's Flowers, which is the case out of Washington State with a unanimous Washington State Supreme Court decision saying that a flower shop there did not have the right to refuse service to a different gay couple. And I think ADF is out there very much doing full court press right now, trying to make the case that the mere fact that the AG in that case enforced the law is evidence of bias. If the court, depending on what, that case will tell us a lot about, and what the court does with that cert petition, I think will tell us a lot about what they're concerned with. It may be that they just grant, vacate, and remand for further consideration by the state courts, but I think that should hopefully give us some indication of how far they're willing to let this line go.
And, I have to say, it's incredibly dangerous to make predictions about these things. And so I'm going to go out on a limb here, and I will probably get burned for it. But there is a passage in Justice Kennedy's opinion where he references the need for state and lower federal courts to continue grappling with these issues in order to figure out if there are administrable free speech clause standards, for example, that could play some role here. And I think it's possible that they took this case and realized once they really grappled with the briefing and with the First Amendment issues that they weren't ready to address this question. I mean, maybe they weren't ready to reject the claim altogether, but they certainly weren't ready to find that there's an affirmative speech clause claim here. And they seized upon this characterization of the record in order to dispose of this one case. And once again, it's dangerous to make predictions. I think that they're going to deny cert on Arlene Flowers. And I think that they're not going to be interested in taking another one of these cases for a while until and unless there's a serious disagreement among lower state and federal courts on these questions. And at this point, there really isn't a serious disagreement among state and federal courts.
Well, thank you. I think, again, that's going to get, as we flesh out more about what the implications are, that obviously is perhaps a good thing to flesh out a little bit more what that means and let them see some cases where some of the tensions that were involved in this particular case between, about the issue of whether artistry was really at play, whether the baker, Jack Phillips, really was willing to sell something off the rack or not. Those kind of questions are somewhat messier here, in addition to the fact that there was the commissioner presence, which is not true in Arlene Flowers, where, that went straight to litigation. So that may be good, but it also certainly extends the pain that the LGBT community and perhaps other communities need to go through as we work out, what's permissible conduct from these shop owners in the meantime. The last just minor technical question I wanted to ask and direct to Rose just for a quick answer before we move more to substance is that many of our members have been curious about what's likely to actually happen procedurally in this case going forward. The ruling, of course, actually overturned the decision of the Colorado Court of Appeals, which had upheld the Colorado Commission's ruling, and because the state Supreme Court had denied certiorari, it went straight to SCOTUS from that Court of Appeals. So what happens now? Is it possible for this to end up back in the Colorado Commission?
So the fact is that my understanding is that the baker has now said that he's going to resume making wedding cakes and selling wedding cakes only to straight couples. So it is theoretically possible that this issue could end up back there. I think because the court reversed rather than remanded, this decision is not, this particular factual dispute is not going to be back before the commission.
Thank you. Okay, so we're going to move to some more substantive matters, and I'm going to start by taking a question from one of our members who asked about the significance of the court had
in Colorado.
Yes, in Colorado. A member from Colorado, great. Who asked about the significance of Justice Kennedy's placing some emphasis on the fact that Colorado, as a state, did not recognize marriage equality at the time that these facts happened, and only did so later. And so I'm curious what you both think about that, and whether things might be a different outcome if only that, well, assuming there were not these procedural issues that clearly the court was distressed about, does it go to the credibility and the intent of the baker in a meaningful way if that baker is relying on the fact that their own state does not recognize marriage equality, as opposed to now when all states should be doing so?
I have to say, I'm sorry, I'll jump in first.
Yes, go.
Quick. I think that's mostly sort of hand-waving, with all due respect to Justice Kennedy, in the sort of direction of characterizing people like the business owner of this bakery as good people who just have a principled disagreement, as opposed to people who have bigoted views. There's a lot of sort of virtue signaling on the part of the court in the direction of the litigants who want to use their religious belief as a basis for turning away LGBT customers. But I will say this as well. One of the earlier cases in this field that people may be familiar with was a case involving a wedding photography company out of New Mexico, where I was the lawyer on behalf of the lesbian couple that was turned away from this business. And when I argued the case in front of the New Mexico Supreme Court, one of the questions that I got from the bench was, what if they had simply said, we're turning you away because you can't get legally married, and we only provide services to people who are legally married? And I said, well, of course, that's not what happened in this case. But if on facts like that, the court would have to decide whether that was a pretextual basis for discrimination or whether that was a genuine explanation for why they were turning the couple away from the business. And that idea that there might be sort of other reasons for turning away gay couples other than discrimination has kind of been in the atmosphere in a lot of these cases. And interestingly, by saying, well, this baker was perhaps understandable in its conclusion that it didn't want to serve these couples because, after all, they couldn't get legally married, what everyone thinks about the legitimacy of that argument, now that we have Obergefell, and now that all gay couples can get legally married, it's almost sort of taking that argument off the table and indicating that today it would be an unavailable way of trying to suggest that there was no discrimination. So I actually saw it as both as sort of giving a little bit of symbolic benefit to the ADF side, but giving a little bit of practical benefit to the pro-equality side.
Thank you. So one thing that I think was the subject of a great deal of writing and discussion and even some court arguments prior to the actual ruling was the relative importance of the fact issue that seemed to be somewhat unresolved here, that I mentioned earlier, about whether Jack Phillips really offered to sell Charlie Craig and David Mullins something that was, so to speak, off the rack, and simply was refusing to make a personalized cake. The opinion mentioned that there was evidence at the commission hearing that Jack Phillips, the baker, had declined it probably around 6 times previously to bake for same-sex couples, including refusing to sell cupcakes to a lesbian couple for their commitment celebration, and that ostensibly because the shop had a policy of not selling baked goods to same-sex couples for this type of event. So the commission, the Colorado Commission, clearly viewed that history as indicating that Jack Phillips' actions weren't just about personalized baked goods. Justice Kennedy mentioned that, but didn't reach the question of how that distinction mattered because he thought that the procedural issue tainted all the fact-finding. How do you all see that shaping up? It was certainly, this question of artistry and the role of artistry was very much the hot issue in advance, but then didn't turn out to be that important to the opinion. What do you see there?
from my perspective, I think ultimately the question is not whether or not a cake is artistic. The question is not whether or not, and even the question is not whether or not they were seeking a custom wedding cake. It's whether a business owner has to sell the same products on the same terms that they sell them to other people. And so if you sell custom wedding cakes to straight people for their weddings, you should sell them to gay couples for their weddings. That's not to say that the bakeries can't have rules about the kind of cakes that they make. They can't have, they may have a policy that says we don't want to work with fondant, or we only like certain kinds of buttercream, or, any number of neutral policies that have to do with their artistic expression, including policies around, we won't make offensive cakes. We won't make cakes with nudity on them. We won't do X, Y, or Z. Those don't run afoul of the law as long as you're selling the same things to other people. But to me, it's been a little bit of a red herring to focus on whether or not they had a conversation about the design they wanted. I mean, to be clear, they did not have any conversation about what kind of a design they wanted. As soon as they sat down at the counter with them and said that it was, they were the folks getting married, he said, I won't do that. But I don't think, I think that has gotten sort of undue emphasis in the discussion from my perspective.
I agree with that 100%. And I think that the same analysis would apply if you were a business that operates as a public accommodation and the service you offered was, we will write the story of your wedding. Come in and we will write a narrative account of your wedding that will be beautiful and poetic. Or we will paint a portrait from scratch of the couple. It doesn't matter. The point is not more or less artistry that is involved in the goods and services that you offer. The point is that you're offering goods and services to the general public. You have to do it on an equal basis without discriminating. And you have to do it because you're not engaged in your own act of expression when you offer goods and services. You're creating a product for the customer. That should be the principle.
Thank you. So we know that the opinion and the concurrences certainly contain a great deal of information for us about where the justices are sitting on the question about how religious refusals intersect with LGBT people and whether or not that was the ultimate basis for the ruling or not. There's a lot in there. And you've talked about that in some prior answers you've given here. Do you think that the opinion is sending somewhat of a message of empowerment to groups like ADF and Liberty Counsel who bring and fund these cases? And what does our side need to be preparing for and thinking of ourselves as, LGBTQ and allied members of the LGBT bar who are the front line of defense for our community as this issue is going to wend its way through the courts?
From my perspective, I think it's critically important that we not buy into the framing that ADF is pushing. I don't think we should act as if these cases take away our tools of enforcing non-discrimination laws. I think we should act as if this case was about a unique set of facts involving, allegations of improper conduct by the commission, and we should continue to both bring cases to where there is discrimination, and to tell stories that really make clear the harm of that discrimination. Because I think the work that so many organizations did and individuals did to try being brave enough to tell their stories was a big part of why we got a decision that was focused on the commission, not about pitting the right, and a decision from a range of justices, including, who joined that majority opinion, a decision that affirmed the dignity of same-sex couples in a way that I think is very powerful and is a tool that we should not be letting go. So I think we have to be careful. We have to be strategic about the kind of cases that we bring. But I think we should not fall into the frame that ADF and others are pushing here.
I agree with that. The only thing I would add is that these cases have forced us to get better at talking about anti-discrimination laws and what they're for and how they operate. and where anti-discrimination laws are tough laws to enforce on the facts sometimes. And there's nothing wrong with that. There's nothing that we should shy away from in admitting that these are hard cases sometimes. We have been confronting the question of how you enforce anti-discrimination laws at a national level for over 50 years now. And, lawyers at places like the ACLU have gotten very, very good at explaining how these laws operate. And I think that's some of the wisdom that we need to be putting front and center right now, because that's part of the way that we reclaim the narrative.
Thank you. And my last formal question, and then I'd love to have each of you say some final words about thoughts that we haven't covered yet. My last formal question really relates to the consequences of the language of the case and its wording, given that, as always, there's always uncertainty regarding the future makeup of the court. We may be feeling particularly some of that anxiety right now, with Justice Kennedy having been signaling that he may be considering retirement over the next couple of years, and certainly we have some of our more historically friendly justices aging a bit. How do you feel? What is it looking like for you as the cases that are coming through the pipeline wend their way up, and particularly if you're right, Tobias, and Arlene Flowers is not granted cert? How do you feel that plays out, given who signed on to the majority opinion and the statements that are in there from presumably led by Justice Kennedy?
I guess on this, I will be more cautious than I was before when it comes to making predictions. I don't read a lot into the fact that several of the more conservative members of the court signed an opinion that had good language in it. In the process of counting votes and in the process of arriving at a majority, justices will often sign opinions that have things in them that they're not thrilled with, and then feel very free to step away from them in subsequent cases. So I think that there is reason for some optimism that the court has signaled in this opinion that there are several general principles about the enforceability of anti-discrimination laws in most cases in the commercial marketplace, which the court said, about the general principle that religious objections are not usually a basis for claiming an exemption from a neutral law, which the court reiterated, and the idea that it would be difficult, even if one is sympathetic to it, to start going down the path of articulating First Amendment free speech exemptions to anti-discrimination laws in the commercial marketplace. I think those are all very promising, and I think we will certainly be emphasizing those in future litigation in cases like this. But we also need to be very clear that ADF and organizations like them are a machine, and they are very good at distortion, and they are very good at oversimplification, and they are trying to characterize this opinion as opening up a new front on the war against anti-discrimination laws. And I think we have to be really vigilant, because we've got a fight ahead of us.
Rose, did you have anything to add?
Yeah, no, I absolutely agree with that, and I think we've seen a continual pushback against protections and equality for LGBT people, whether that's through trying to stop us from getting the freedom to marry in the first place, or trying to push transgender people out of public life entirely by barring access to facilities, and just generally demeaning and denying the existence of trans people. And I think they're using a claim for religious exemptions in the same way. I think it's not that their beliefs are not sincere, but that it's a tactic, and it's a tactic with an end goal of really preserving a worldview that is increasingly that they're losing, and this is a way for them to be able to push back, and we all have to be ready to respond to that. And I think as we think about calls for the Equality Act, which would, for example, be a national non-discrimination law that would expand protections for LGBT people and for from sex discrimination and for a range of discrimination, thinking about how we get towards national protections from discrimination that don't have these kinds of sweeping carve-outs is a really, really important one.
Wonderful. Do either of you have any final words you'd like to say for our members?
I guess I'll just say, I've worked with the ACLU on these issues for, almost 8 or 9 years now, and they really are a force. I don't know if I'm allowed to do this, but you all should support the ACLU in this work. There are many great lawyers and organizations doing this work, and they didn't put me up to saying this, but the ACLU is doing really important work here, and you should support their leadership.
Thank you, Tobias. That's very, very sweet, and y'all should support Tobias too because he's amazing. But no, I think we're in for a really hard fight, and it's a hard fight on so many fronts, and it's one that's not just about LGBTQ rights. And as I look at the judiciary, I know one of the questions was about sort of what's the composition of the courts. It's scary. We've seen a number of appointments that are very ideologically conservative at the circuit level. And just remembering that courts aren't the only way forward, and that some of our biggest, I don't view this to be really clear. I don't view this decision as disappointing as it is. I don't view this as a huge loss for us right now. Hopefully I won't come to regret that. But I view it as a missed opportunity, but an opportunity that also allowed us to tell stories and to share the experiences of LGBTQ people from discrimination. I think about Paul Smith's op-ed talking about what being a gay person in America, even for somebody like him, means, and what kinds of questions you ask. I think about my colleague Ria Tobacco-Mar, who similarly wrote incredibly eloquently and powerfully about what it means to be a lesbian and wonder what's going to happen when you go about our day-to-day lives. And I think all of us, allies and members of the community, the LGBT community, can move people by sharing our experiences and stories. And I think thinking about ways that lawyers can do that both through our work in court and through our conversations is a really important tool that we all have.
Beautiful. Thank you both. And really, truly, I want to echo what you both said about each other, but we truly thank you from the bar for all of the leadership that both of you have taken in, and that your organizations have taken in leading this battle for us on the fighting these religious refusals and protecting the community. It makes a huge difference. And thank you both for joining us today. I appreciate your expertise. I'm going to hand it back to Darcy for some final words.
Hi, this is Darcy. I'm the Executive Director. I just want to say that we certainly have our work cut out for us in the future as we will see these cases continue. So we would like to thank you all for listening, and if we would like for us to continue to pull together this quality of programming for you, we ask that you join our organization today. And also, please be aware, our annual conference and career fair, lovingly referred to as Lavender Law, which will be held in New York City at the Marriott Marquis Times Square, August 8th through the 10th. The hotel is selling out. So if you need to get a reservation at the hotel, please do so immediately because it is selling out. And registration is available online. We are certain to break all of our registration and attendance records. So do please register early. We look forward to seeing you in August, and please have a wonderful, wonderful rest of the week. Thank you.